many years, the Canadian government has been trying to assimilate the First Nations people across Canada. The Canadian and British government mandated with legislation, policies, and cultural disruption to change the First Nations people in Canada. The First Nations people went through a series of changes during the Royal Proclamation in 1763, the Gradual Civilization Act of 1857, the British North America Act of 1867, the Indian Enfranchisement Act of 1867, the Indian Act of 1876, the Red and White Paper, and the Bill C-31.
The Royal Proclamation of 1763 is a document that set out guidelines for European settlement of Aboriginal territories in what is now North America. It was issued by King George III in 1763 to officially claim British territory in North America after the victory over the French in the 7 Years' War. The Royal Proclamation explicitly states that Aboriginal title has existed and continues to exist, and that all land would be considered Aboriginal land until ceded by treaty. The Royal Proclamation forbade settlers from claiming land from the Aboriginal occupants unless it had been first bought by the Crown and then sold to the settlers. The Royal Proclamation also states that only the Crown can buy land from the First Nations people. A number of treaties across Canada are a result of the Royal Proclamation and the Crown wanting more land. The Royal Proclamation is recognised as an important first step towards the recognition of existing Aboriginal rights and title, including the right to self-determination. In this regard, the Royal Proclamation is sometimes called the Indian Magna Carta.
The Gradual Civilization Act of 1857 was an act that passed by the 5th Parliament of the Province of Canada. The act required male Indians and Métis over the age of 21 to read, write, and speak either English or French, and to choose an approved surname by which they would be legally recognized. By the application of this act, Indian Métis males would lose their legal status rights as well as any Indian claims that would become British subjects. Through with far fewer rights, it was called enfranchisement, and was one of the many policies that would be passed too aggressively. The Gradual Civilization removed all legal distinction between First Nations people and other Canadians. The government thought eliminating the legal distinction would abolish the First Nations' traditional ways of life and lead First Nations into mainstream economy. At the same time, the Act created a legal distinction by definition, the term Indian. Legislation and policy aimed at civilizing First Nations people demonstrated a clear cultural bias on the part of the government officials. The Act established criteria for judging First Nations men suitable for enfranchisement. The British North America Act created Dominion of Canada in 1867. The British North America Act was drafted by Canadians at the Quebec Conference in Canadian Confederation in 1864 and passed without amendment by the British Parliament in 1867. The British North American Act set out the rules for the government of the new federal nation. It established a British-style parliament with the House of Commons and Senate, and set out the division of power between federal government and provincial government. The British North America Act was signed by Queen Victoria on March 29, 1867, and came into effect on July 1, 1867. In Section 91 of the British North America Act, transferred the relationship the British government had established with First Nations people to the Canadian government, and did this without consulting First Nations people. Even though Britain had made important amendments to First Nations people, Canada patriated the British North American Act, which made the Act a Canadian law instead of a British one. Is a legal process for tormenting a person's Indian status and conferring full Canadian citizenship. Aboriginal people have been enfranchised
for serving in the Canadian Armed Forces, gaining a university education, for leaving reserves for long periods. There's a Canadian statute that concerns registered Indians, their bands and system of Indian reserves, first passed in 1876 and is still in force with amendments. In 1876, the Indian Act is born. Treaties were being made. In 1885, outlawing several traditional ceremonies such as the potlatches. Sundance was outlawed in 1895. 1905, the removal of Indians from reserves. 1911, downsizing portion of reserves for roads, railway, and public works. In this Indian residential school, there was 139 Indian residential schools, and it's estimated over 150,000 First Nations, Inuit, Métis children ages 4 to 16 years attended Indian residential schools in Canada. The last residential school closed was in Saskatchewan in 1996. And here's a picture of a before and after of a boy, how he looked before residential school and how he looked while in residential school.
In 1969, Pierre Trudeau was recently elected Prime Minister, envisioned a Canada in which every citizen enjoyed equal rights and privileges. This vision included a radical redefinition of the government's relationship with the First Nations people. Jean Chrétien, who was then Indian Affairs Minister, presented a white paper titled Statement of the Government of Canada on Indian Policy 1969. In order to give First Nations people equal status as Canadian citizens, the government planned to do away with their special status designed in the treaties. The government planned to phase out the Department of Indian Affairs, eliminate Indian status, and turn over responsibility for First Nations programs to the province. This meant that the federal government would no longer be responsible for First Nations education. And the paper, with a nearly anonymous outcry of opposition and outrage in the eyes of the First Nations people, the government was trying to back away from its historical treaty obligations. The 1970 Red Paper. Harold Cardinal, who was the youngest elected president of the Indian Association of Alberta, he wrote The Unjust Society in response to the White Paper. It was the first time mainstream Canadian society heard the views of First Nation people firsthand. This was the Citizen Plus paper, later called the Red Paper. The Red Paper explained the widespread opposition from status Indians, and the Red Paper countered all the proposals of the White Paper. An Aboriginal delegation backed by other Canadian citizens met with the government and successfully convinced it to radically change its policies and positions. Many believe Harold Cardinal created a turning point for First Nation rights in Canada through his work.
Bill C-31 is a bill to amend the Indian Act. It passed into law in April 1985 to bring the Indian Act into line with gender equality under the Canadian Charter of Rights and Freedoms. The bill had proposed many modifications to sections of the Indian Act, including changes to Indian status and band membership. The bill had three major goals: one, to address gender discrimination of the Indian Act; to restore Indian status to those who had been forcibly enfranchised due to previous discriminatory provisions; and to allow bands to control their own band membership as a step towards self-government. Before Bill C-31 was passed into law, there were three significant court cases against Canada. The 3 cases involved women who had lost their Indian status by marrying a non-status male. The 3 women are Jeanette Lavelle, Yvonne Bedard, and Sandra Loyboys. They all lost their cases against Canada. It wasn't until Sandra Loyboys brought her case to the United Nations Human Rights Committee that they found that Canada was in breach of the International Covenant on Civil and Political Rights.
Throughout these series of acts implemented by the Canadian and British government, the First Nations people across Canada adapted to them with struggle, hunger, abuse, cultural loss, and sometimes even death occurred. This has made the First Nations people across Canada a strong link in today's modern world.